Hello, good morning and welcome. Thank you for joining us. My name is Nicola and I'm the Principal Consultant here at Handley Gill. Handley Gill is a specialist legal, regulatory and compliance consultancy based in London. We have particular specialisms in data protection, AI, content moderation and online safety and related ESG issues. We work with a range of clients across the UK and globally, spanning both the public and private sectors, in industries from IT and technology, law enforcement, media and online platforms, education and finance. We also work with individuals such as content creators or those who are concerned that their rights have been infringed. Today's event is part of the official AI Fringe to coincide with the government's AI Safety Summit, which concludes today. The focus of the Government Summit is Frontier AI. Frontier AI is a term used to describe foundation models, so generic or non-task specific AI models, which can be adapted to a range of tasks and which, due to their vast training data and general applicability, are at the cutting edge of AI capability. In the 2023 scientific research paper, Frontier AI Regulation, Managing Emerging Risks to Public Safety, Frontier AI models were defined as highly capable foundation models that could possess dangerous capabilities sufficient to suppose severe risks to public safety. Particular risks identified in the government's pre-summit discussion paper include risks of mis- or disinformation, something we're already seeing in the context of the Israel-Gaza conflict in the form of deepfakes and other influence operations, labour market disruption, the development of biological or chemical weapons, cyber attack against critical infrastructure, through to what is described as permanent and catastrophic loss of control, the existential risk that the machines will exert and gain control. Today, instead of focusing on the what-ifs of the potential AI models of the future, which are admittedly concerning, as any of you who have seen the Will Smith classic film, I, Robot will know, we wanted to think about how we can use the AI that is widely available now more safely and responsibly, consistent with legal, regulatory and social obligations. Hence the title of today's webinar, Practical mAgIc, a practical guide to deploying AI safely. Now, if you have been following the news in AI this week, you will know that the EU's trilogue negotiations in relation to the AI Act continue. US President Biden issued an executive order governing AI on Monday, and this was closely followed by the G7 leaders issuing international guiding principles and a code of conduct for organisations developing advanced AI systems pursuant to the Hiroshima process. Then, yesterday, at the opening of the AI Safety Summit, the British government joined multiple states in issuing the Bletchley Declaration, which affirmed that, for the good of all, AI should be designed, developed, deployed and used in a manner that is safe, in such a way as to be human-centric, trustworthy and responsible. Incidentally, details of all of these resources can be found on the AI page of the resources section of our website at handleygill.com. These announcements go to show the sheer pace at which the regulation of artificial intelligence, both its development and its use, is developing. In this innovative field, when thinking about our approach, it's important to start with the application of existing legal principles to these novel situations, to identify and to seek to quantify the risks that are presented, consider how these might be mitigated, drawing from the themes arising from emerging regulation and applying established principles from related fields. As such, today we propose to consider the opportunities presented by AI, the risks inherent in AI models, the additional risks that arise from the use of AI, and our recommendations for implementing practical safeguards. Before we get to questions, we will also be unveiling our beta AI CAN analysis tool. For those of you joining us live, you'll see we've posted a poll, rest assured it is anonymous, to ask whether you have used a specific publicly available AI tool, ChatGPT, for work purposes. We'd love it if you would answer that poll, and we'll come back to those results just in a moment. To be clear, it is absolutely not the purpose of our webinar today to tell organisations not to use AI. AI will undoubtedly represent one of the greatest industrial advances of our time. The Stanford professor, whose name I'm about to butcher, Eric Brynjolfsson, director of its Digital Economy Lab, posited in an interview with Fortune magazine that he anticipated about a doubling of productivity growth in the coming decade as a result of AI technologies. In one of his experiments testing the impact on productivity of the use of a generative AI model in a call centre environment, they used a controlled environment where only some staff had access to the tool and others didn't. Those workers with access saw measurably increased productivity, with the most marked impact in the least experienced workers, whose productivity increased by in excess of a third, and even for experienced workers, they saw productivity increases of in excess of 10%. The sheer ability of AI tools to process and analyse data at scale means they have huge potential for AI-enabled drug discovery, for example. Could AI help develop a new generation of antibiotics to combat resistance? They could be used in the health service to deliver improved outcomes more quickly by using AI to analyse diagnostic imaging. But as is so often the case with opportunity comes risk. The development and the nature of public AI, by which we mean free AI tools or those made available on commercial terms, means that there can be embedded risks that users must be aware of and consider how to address. Thinking first about liability. Did you know that ChatGPT's terms and conditions, as at the 14th of March this year, define both input, your prompt, and output, ChatGPT's response to your prompt, as content, and make users liable for content? The terms state you are responsible for content, including for ensuring that it does not violate any applicable law or these terms. It goes on, you will defend, indemnify and hold harmless us, our affiliates and our personnel from and against any claims, losses and expenses, including attorneys' fees arising from or relating to your use of the services, including your content, products or services you develop or offer in connection with the services, and your breach of these terms or violation of applicable law. You are liable to ChatGPT for its output and, as we'll come to discuss, any inaccuracy or unlawfulness therein, whether or not you could have reasonably anticipated such an outcome. Now, at this point, we're going to come back to the results of our poll. We asked the users joining us live whether you had used the widely available AI tool ChatGPT for work purposes, and gave you the option of responding yes, no, or please don't tell. We're going to take any please don't tells as yeses, so that reveals that more than 2/3 of you have used ChatGPT for work purposes. But did you know that when you were doing so, you were making your companies liable? We decided not to answer that question today, and we suspect that perhaps not. Thinking about bias and discrimination, AI outputs are necessarily affected by their training data and their machine learning algorithms, both of which can introduce bias and discrimination. In relation to training data, the quality of data can be affected by its source. Scientific evidence suggests that where unfiltered social media data is included in training data for generative AI models, for example, this results in more biased, discriminatory, and generally toxic outcomes. Society and people are biased and do discriminate. Look at our politicians, our lawyers, our business leaders. The ingestion of data about who those people are into an AI model used in a recruitment process to assess who demonstrates the most potential could well infer that being a white man of a certain age who attended a private school are the necessary characteristics for success, and by then recommending such individuals for progression in a recruitment process could serve not only to replicate but also to exacerbate and bake in existing inequalities. Explainability. The black box nature of many AI tools, in particular those that are publicly or commercially available, prevents us, and frankly often even the developers, from understanding how a particular input has resulted in a particular output. All they can tell you is, well, that it is what it is. Now, EU and UK data protection law requires that where personal data is subjected to automated decision making and profiling, individuals are entitled to, at least in those cases, meaningful information about the logic involved, as well as the significance and the envisaged consequences of processing for the data subject. Insofar as the developer is a data controller, they may simply not be in a position to comply with this legal obligation. Aside from risks around data protection, which we'll talk about more in a minute, and privacy risks, which some AI developers, and perhaps more accurately their providers, have been accused of running what have been referred to as digital sweatshops, often engaging low-paid workers in the world's poorest countries to review and label data to train certain types of AI models. Amid allegations of worker exploitation, it's worth noting that research taken by the Oxford Internet Institute in its Cloud Work Ratings 2023 report revealed that not one of the 15 web-based digital platforms it analysed met minimum standards for fair working practices. So there's clearly potential human rights issues relating to the development of AI, and also ESG concerns. One scientific study made estimations of the likely carbon emissions of various large language models, suggesting that the training of ChatGPT-3 would involve CO2 equivalent emissions of 502 tonnes and some 552 tonnes taking into account data centre emissions. And this was before it was retrained or anyone entered a prompt to use ChatGPT-3. According to the US Environmental Protection Agency's Greenhouse Gas Equivalencies calculator, that is the equivalent of more than 62,000 gallons of gas being consumed. And we mentioned data protection and privacy. Individuals are likely unaware that their personal data has been used to train AI models, or that generative AI models may be producing personal data about them. The accuracy of such data may well be in question, and that there is at least an argument to be made that the gathering of data on such a vast scale by generative AI model developers could constitute profiling. The lawfulness of the processing of personal data by AI model developers is therefore in doubt, and the position of AI developers in relation to their legal status is also an issue. You'll see in many of the terms and conditions for AI models that are currently available, the developers are seeking to position themselves as data processors, acting only on behalf of a data controller who is the end user, potentially trying to shift their liability from themselves over to users, even though obviously much of the processing of personal data took place before any user ever touched the model. Now, we've mentioned the hoovering up of data, personal or otherwise, to train AI models, and it isn't clear that this has been done lawfully either. A number of authors in the US, for example, have brought copyright proceedings against OpenAI, alleging that it used their copyright works to train its AI and to inform its output, and the output constitutes an infringing work. In UK law, possessing infringing work in the course of business where you know or have reason to believe that the work is infringing is unlawful, and therefore you may be at risk as a consequence of being aware that this is an issue in relation to generative AI. So thinking about how you're using AI can be really important, and we'll come to talk about the practical implications for users and steps users can take later on in the webinar. Similar to some of the data protection risks, the nature of generative AI can result in wider reputational harms where outputs are defamatory or constitute a misuse of private information, because even information which is false but private in nature can found such a claim. So these are the types of issues that AI is kind of inherent in AI, by then particularly generative AI and the use of large language models in the way they've been trained, the way they've been developed, and then, as we'll come to talk about, the way they're going to be used. Research by the Ada Lovelace Institute suggests that the public is not inherently averse to the use of AI. The public wants to see AI used in appropriate circumstances to support public services, for example, but does have concerns where this might have outcomes for people's lives, in the decision-making in relation to entitlement to benefits, for example. And the public strongly supports regulation and guardrails to protect individual rights. So thinking about if your organisation wants to actually use AI, some of those risks we've already discussed that are inherent in it will flow through to you and appear as implementation risks, but there are additional risks that you take on when you use AI models. We've discussed the issue of explainability in the context of developers of AI tools, and this applies tenfold in relation to users of AI tools who are even further removed from the decision-making logic than the developers. You're unlikely to know what training data has been used, how the model has been developed. So trying to be able to explain to individuals affected by your use of the model how you've got from A to B is very challenging. Many AI tools seek to position themselves as data processors in all contexts, as we've explained. Effectively doing so, though, would shift their failure to design a product that offers privacy by design onto their users. It's important to be aware that generative AI is not the same as a Google search. Generative AI uses training data to determine the most probabilistic response to a prompt, and it's really important to understand the difference. We're going to pray and aid now the cautionary tale of the American lawyer who heard about ChatGPT from his children over breakfast and, faced with limited legal research tools at his firm, used ChatGPT to support him in preparing a brief in a claim on behalf of a client. He'd been delighted that ChatGPT was able to provide him with a number of favourable precedents which were referenced in the brief that was filed with the court and served on the defendant. The defendant then took issue with the brief when it claimed to the judge that it had been unable to source a number of the reference precedents in the plaintiff's brief, and the judge so directed the plaintiff's lawyers to produce copies of the precedents. So the attorney who was concerned dutifully went back to ChatGPT and prompted it to produce the judgments in the precedents that it had cited originally. And ChatGPT did produce them, quite literally. ChatGPT produced entirely made-up judgments with fake judges and citations. The attorney, however, continued to be oblivious to this and delivered the precedents to the court. It was only after the defendant's lawyers received them and had to go back to the judge to complain that the judgments were fake that everyone involved in that case became aware of the potential of ChatGPT as a fantasy author and its limitations as a tool for legal research. The attorney and his firm were summoned to court and faced potential disbarment, but were instead subjected to a fine. Nevertheless, it's a mistake you won't want to repeat. Reliability in the context of AI relates to the idea that entering the same inputs should result in the same outputs, that you should have consistency of response. Many AI tools, and in particular generative AI tools, are unable to deliver on this, and this risk must therefore be taken into account in considering whether an AI tool is appropriate for a particular use case. We talked already about personal data and who's responsible for the processing of personal data in the context of AI tools. Despite the fact that AI developers have collected vast quantities of personal data, many seek to make you, the user, responsible for their use of data through data processing agreements, and that is something to be wary of, particularly when the lawfulness of even the collection of that data may be in doubt. Any processing of personal data in the EU and the UK must be fair and lawful, and personal data must be accurate and kept up to date. In relation to generative AI, the probabilistic nature of responses means that AI can literally generate new data, and there's no guarantee that this will be true or indeed have any basis in fact at all. There are multiple examples of individuals who've raised complaints due to inaccurate outputs which involve personal data, such as where AI models have accused individuals of having been convicted of criminal offences, and there's no basis for that whatsoever. Processing activities deemed to represent a high risk in the absence of safeguards are obliged to be reported to the relevant supervisory authority. So in the UK, that would be the Information Commissioner. The efficacy of that obligation to protect the rights of individuals is in doubt, though, since the Information Commissioner's Office revealed to us at Handley Gill that not one police force in the UK had consulted it in relation to the use of live facial recognition technologies under the equivalent provision for law enforcement processing in Part 3 of the Data Protection Act. But if you are going to undertake any kind of high-risk processing using AI, that is something that almost inevitably you should be considering. Now, it's important to understand the terms and conditions imposed by AI tools, and indeed all providers of services who may want to use your data for the purposes of their own development of AI, and to take appropriate measures to protect your data. The need for vast data sets on which to train AI tools means that organisations are seeking to hoover up data and are looking to impose terms which enable them to use your inputs and outputs or other content for their own purposes. The hoo-ha earlier this year around Zoom's proposed change to its terms and conditions, which a number of people understood as meaning that Zoom was now going to take your content and use it to train its own AI, for example, is an example of how these issues can arise. Uploading spreadsheets of data for processing and analysis, for example, can result in the loss of control of that data in the context of an AI model, potentially resulting in competitors being able to access the benefit of it, and which, if it's confidential or commercially sensitive, could not only have legal but also regulatory implications. We touched on human rights in the context of the development of AI and how people are treated in relation to that, but your use of AI also has the potential to infringe human or other fundamental rights. The use case of facial recognition, for example, which is now not only being done by law enforcement but frequently by retailers, for example, can have implications for privacy rights of individuals. If your organisation is engaged in relation to delivering on its environmental, social and governance agenda, and particularly if it follows a reporting framework that includes supply chain ESG risk, then the human rights arising from the development of AI will kind of flow through to you and your organisation. Similarly, the environmental impact of both your use of AI and its development are going to be relevant in the same way. In relation to your use of generative AI, it has been suggested that the energy consumed in responding to a prompt could exceed 100 times as much as a Google search. So thinking in your organisation about when it's appropriate to use AI as opposed to other tools could be really important. Now, AI models need to be cyber secure. You need to be able to interact with the model securely without the risk of interference. The model itself should be secure so that it cannot be manipulated, and the inputs and outputs to the model should be stored securely. So making sure your information security risk assessment is undertaken in relation to AI in the same way as you would to any other third-party supplier is one of the factors and one of the tasks you should be undertaking. Aside from meeting public expectations in relation to the use of AI with a view to engendering trust, where AI is used to process personal data, EU and UK data protection law requires individuals are entitled to know the mere fact that they are subject to automated decision-making and profiling, as well as to the explainability information we've already talked about. Transparency around the use of AI models can also be a really effective mechanism to support individuals in exercising critical thinking in relation to AI outputs. So enabling people to understand how AI has been developed and what its training data is can encourage individuals to then think about whether who knows best, them or the computer. So thinking about those concerns, there are a range of measures that organisations can take to deploy AI safely and responsibly. And even organisations that have already started using AI or implemented safeguards need to ensure that those are not static, but that they are subject to continuous assessment and periodic review, and are revisited both as new laws and regulations emerge, but also as our understanding of the development and risks arising from AI tools develops. Depending on the nature of the proposed activity, as well as the industry of the user, which can bring sector-specific regs into play, whether and the extent to which each of the safeguards we identify as necessary will vary. So, for example, if you're using AI, generative AI models to, for example, ask them to give you an outline of what a communications plan might look like, and you don't give them particular specific details about your company or your organisation, you maybe give them a prompt that in relation to your industry, but you don't give them specifics and you don't give them personal data, and you're not providing confidential or commercially sensitive information, that is going to be a completely different measure of risk compared to a tool where you want to use confidential, commercially sensitive information or IP, personal data. That's the other end of the scale. So measures we advocate considering include briefing the board or other organisational leadership on AI and seeking a strategic decision as to the organisation's AI risk appetite. Preparing a policy on the use of AI which is accessible to staff and details what AI can be used for. What AI can be used for, what use cases, upon what conditions and subject to what safeguards. Making sure that you provide training and wider awareness raising to staff on AI and the specific AI tools they can access. Taking steps to block access to AI tools that are not authorised from your systems and networks. Identifying your intended use cases and conducting an AI risk assessment in relation to each. So at Handley Gill, we've developed a bespoke modular AI risk assessment, which brings together the elements of a data protection risk assessment, a cyber security assessment with which all organisations are likely to be familiar, as well as from processes with which perhaps public sector organisations will have more familiarity, such as human rights impact assessments, quality impact assessments, community impact assessments. And we've also designed additional or alternate modules for specific industries such as financial services, law enforcement, journalism, education, to try and bring together kind of holistically all of those different potential risks to identify which are appropriate to your use case and your organisation, and ensure that you've actually then done a thorough think through and also balance the different opportunities and risks off against each other, because they can sometimes conflict. Only authorise the use of AI tools appropriate to the risk of each relevant use case. Design and procure AI models with built-in safeguards. Establish a gateway process for AI procurements and deployments. Implement safeguards appropriate to the nature and scale of risk. Consult, where possible, with affected individuals in advance, and if you can't consult with affected individuals, consider whether you can consult with representatives, or even do what we use in the data protection sphere and we refer to at Handley Gill as data protection stewards. So the idea that you'll engage a third party with relevant expertise to effectively come in and argue against you. What the courts might have, they would call an amicus curiae, but basically have someone to come in and do the arguing for the person who can't argue for themselves, to try and kind of hold yourselves to account and make sure you're meeting high standards. Establish a beta phase of testing in AI, whereby the use of AI is run alongside traditional approaches to identify benefits as well as divergences which can reveal potential deficiencies in the AI model. Be transparent about your use of AI, particularly where individuals are affected. Test and monitor the operation of the AI model to confirm its accuracy, reliability and propriety. Establish a reporting mechanism to enable users to report unexpected or inappropriate outcomes and act upon those reports. Monitor the way AI is being used in practice and whether it is impacting user behaviour in unexpected ways. This could be, for example, where even experienced and knowledgeable staff start to second guess themselves when presented with an outcome recommended by AI, but which is contrary to their perception and experience. Scientific research to date suggests that even the most experienced of us are more likely to trust the computer's output than our own decision. So that's something that's really important to bear in mind. That flows through to the next point, which is that where AI is used for decision making impacting individuals, ensure that AI is not solely relied upon. In some cases that's a legal requirement. In any event, thinking about how humans and AI can work together and AI can be a support to human decision making rather than a replacement for it is really beneficial. Establish a governance and oversight mechanism. Consider the impact of the use of AI by your supply chain, both for your staff and for your organisation's risk profile. So, for example, taking the Zoom example and the Zoom's proposed change to its terms and conditions, which it then subsequently said it never intended to do. But if a supplier were to use a provider of a service whose terms and conditions did say, for example, we're going to use the content of your meetings to train our AI. So we're now going to be using those recordings. That could have really serious implications for you, for the personal data of your staff, for your IP, for your commercial confidentiality. And therefore you might want to consider, what is our position? Do we say that we use, say, Microsoft Teams, for example, and we are not going to allow our staff, we're always going to be the ones to set up and kind of run meetings. We're not going to use third-party services. Easier said than done, but something that's at least worth considering and having given some thought to. And then after all of that, just rinse and repeat. Rinse and repeat. It's imperative that you continue to revisit your approach as our understanding of generic AI risks and your understanding of the specific risks arising from your organisation's use of AI emerge. And as the legal and regulatory approach to AI develops, we at the very beginning we mentioned the EU AI Act is expected. The UK is saying it's not intending right now to issue new AI legislation, but a Conservative peer who's on the Science, Innovation and Technology Committee has now tabled a private member's bill to regulate AI. So there are developments and things are moving really, really quickly. So it's something that you've got to keep pace with. And finally, establish a process for individuals to raise concerns and, if necessary, seek redress. If your organisation is already using or is thinking about using AI, we're delighted today to be able to launch the beta version of our AI CAN analysis tool, our artificial intelligence capability and needs analysis. The tool is available on our website right now at handleygill.com/AI-CAN-capability-analysis. It is intended to support organisations to gain an understanding of their level of maturity in relation to their adoption of AI and to highlight the measures they should be considering when seeking to be responsible users of AI. The tool requires you to answer 25 multiple choice questions relating to your organisation's position on the use of AI and the steps it takes to identify, adopt and safeguard appropriate AI tools. Well, it's 25 questions. It should take no longer than 5 to 10 minutes to complete, promise. And the tool is new. It's currently in beta. We'd love your feedback. We also intend to continue to develop the tool as legal and regulatory requirements develop, our understanding of AI risks progresses, and as additional necessary safeguards emerge. So it's worth thinking about maybe doing the test now, saving your results, and then thinking about what measures you might want to take and coming back in a few months' time and retesting and seeing, have you moved on? Are you now considered to be more mature as an organisation? And then as regulations develop, coming back and retesting and then seeing, okay, are we still at the same level of maturity, or is regulation and our understanding of risks now surpassing our maturity and we might need to step up again? If your organisation's results of the AI CAN analysis test indicate that it's still on its journey to AI maturity, at Handley Gill we work with organisations at all levels of AI maturity. Whether you need to go from zero to hero or already have an established approach to AI but want to independently evaluate it against emerging requirements and best practice. Through our great programme, Get Ready to Employ AI Today, we work with organisations to understand their goals and to develop and implement plans to get them there in the right way. We have received some questions in advance of the webinar through the registration form, and there are some questions in the chat as well, so we've picked some of those that we're going to address. The first question we've received is, what human rights issues arise in the context of the use of AI? We've touched on this a little bit. Human rights and wider ethical issues can arise in the development of AI tools as well as in their use. As a user, the issues arising in the development of the tool can have a knock-on effect on you, either because they impact the operation or output of the tool, or because they tarnish your supply chain. As we've said, we live in a biased world. If you were to scrape websites of the world's top firms and use that data to train an AI recruitment tool, the outcome of that would be heavily biased towards late middle-aged white men. So the content of training data influences output. That can lead to discrimination, contrary to Article 14 of the European Convention of Human Rights, as well as in some cases the Equality Act 2010, for which users can then be held responsible. Any ill treatment or harm caused to workers who train data, such as those individuals often in the world's poorest countries who've been engaged in training content moderation AI tools for social media, which require them to view terrorist, child sexual abuse and exploitation material and other similar content, could constitute degrading treatment contrary to Article 5 of the European Convention. And then you have the risks arising from the manner in which AI tools are used. The Cambridge Analytica scandal, for example, demonstrated how behavioural profiling and social media platforms can be utilised in an effort to influence or manipulate public opinion. AI has the potential to turbocharge that kind of activity, with the potential to interfere with the right to free elections under Article 3 of Protocol 1 to the Convention. That's the bit that requires member states to ensure that elections take place in conditions which ensure the free expression of the opinion of the people in the choice of legislature. The use of AI can also affect access to rights. So, for example, taking the right to freedom of assembly and association under Article 11 of the Convention, that's the right to protest. The use of facial recognition technologies by law enforcement, something that's currently being encouraged by the government, but not by the relevant parliamentary committee, could result in an individual attending a protest being identified as a troublemaker, someone who's previously been involved in unlawful activity, public order incidents, for example. That could result in them being immediately arrested and removed from the protest, preventing that individual from exercising their rights. But if you get back to the police station and then it's realised that the facial recognition technology had matched you to a profile, but that was not in fact you, you might find yourself then being de-arrested at that point when verification takes place. By that point, of course, your right to protest has already been interfered with and you probably won't be able to exercise it. The use of AI tools in the context of efforts to clear the immigration and asylum backlog, for example, poses risks, potentially depending on how those cases are assessed, the extent to which human and AI assessments are being used either in tandem or one to support the other, or if AI is effectively the decision maker. And as we've already talked about, the problem here is to make sure that even where AI is intended to be supportive and not the sole decision maker, that's left to humans, you've got to be careful to make sure that that is in fact how AI models are working and how their practical implementation is working, because we as humans do have a tendency to trust the computer over ourselves. A second question we're going to address now is, can our approach to AI governance flex depending on how we use AI? And our answer to that is absolutely. We advocate taking a risk-based approach to AI. That does, of course, require your organisation to understand and articulate its position on AI and to quantify its risk appetite and to identify and then accurately assess the risks arising from its intended use cases. That is how you're going to enable the most appropriate AI tool for your use case to be identified and utilised, and making sure that safeguards relevant to the scale and nature of the risk can be implemented. As I've said, an organisation that permits its staff to use publicly available AI, such as ChatGPT, only to produce, say, a basic marketing strategy, which doesn't involve the sharing of personal, confidential, or other commercially sensitive company information, is going to require a much lighter touch approach, provided it has measures in place to ensure the AI tools that are used are only used as authorised. Somewhere further up the chain might be AI tools that will automatically summarise your meetings, produce minutes and transcripts. And at the complete other end of the scale, for example, a local authority wanting to use AI tools to allocate housing, for example, or a commercial entity wanting to use AI tools for recruitment purposes, you should be engaging in a much more in-depth assessment and considering using not just freely available tools, but commercial or even bespoke AI tools. And some firms are looking to the use of bespoke AI tools where AI is being used on their own servers, for example, data is not being shared, but that is obviously far more expensive. So that comes to the end of our session. Thank you so much for joining us today for Practical mAgIc, a practical guide to deploying AI safely with us at Handley Gill. We hope that we have helped you to formulate your thinking on the issues that can arise when thinking about using AI tools and the practical actions that you can take now to do so more safely, ethically and responsibly. If you are interested in learning more, we would invite you to check out our AI resources page. You can follow us on social media. We have a dedicated X or Twitter account for AI Regulation UK. You can sign up for our newsletter via our website. You can read our ongoing AI Bootcamp blog post series on our website, which includes links to a number of the kind of scientific studies and evidence that we've referenced in our webinar today. And you can also try out our AI CAN analysis tool on our website. All of those you can access via our AI resources page. If you go to handleygill.com and choose knowledge and insights and then resources, you'll find us there. In the meantime, stay safe, stay dry, and we hope to see you at a future event. Thank you very much.